You're facing, you can stay. It's okay. You can stay. Ma'am, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Gentlemen, March 12th, 2025, in Harris County, Texas, a law enforcement officer was notified that a parent sent a threatening text message to a school's text communication system. The law enforcement officer made contact with a complaining witness who stated that the defendant sent him a message to have a grandson's birthday party in his classroom and had spoken with the defendant many times via the same number. The defendant brought 25 cupcakes for the birthday party, and the defendant's grandson took the leftover cupcakes home. The next day, the defendant sent the complaining witness a message that stated, "Were you messing with me returning the leftover cupcakes?" That was on call for. You're supposed to be called for, Judge. That's nasty. Did you know better than to return germs back to us? You have to be so ignorant and have done that. The next time I see you, I will curse you out. No teacher has ever done that, but it has to be you, ignorant dumbass. Defendant called the complaining witness a homosexual slur and further stated, "Fuck with me or my son, and I will stomp on your ass, you piece of shit." The complaining witness stated he felt threatened because the defendant is always coming to school, being disruptive and cursing at people. The school sent the defendant a letter regarding inappropriate behavior and prohibiting her from any on-campus events. On April 1st, 2025, the defendant called the school and cursed at 2 school employees receiving the letter and made further remarks about the complaining witness.
All right. So I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now, as a condition of your bond, not to have any contact with the school and no one with the school and not to go there. Do you understand?
I'm paralyzed. I was attacked.
I just
was just mad.
don't say anything. Just don't have any contact with them. Don't use someone else to try to have contact with them. So if you get someone else to try to relay a message, I will revoke your bond and put you in custody. You understand? Now you've got a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Carson and he will tell you if when you have to go back to court. We will have bond conditions created for you. Once you sign them, at that point, you'll be free to go. Okay?
Thank you.
Yeah, if you don't mind just having her hanging out, I'm going to get the bond conditions created. As soon as she signs, you guys can go.
Thanks, Judge.
Okay, thanks. Hi. How's jail? Great. I'm not going to play this game with you. I'm going to let you out today. But I'm not playing this game with you again. I will test you 50 days from today. If I find that you're using, if you test positive, I'm not going to continue to do this. Do you understand? It is your responsibility. You are old enough to know what choices you're making, whether they're good or whether they're bad. You put something into your mouth that's CBD, anything, you put a joint up to your mouth, you put a vape pen up to your mouth. Just think to yourself, you could be wearing orange for the next 4 months. I'm letting you out today, but this is the last PR bond you get from me. You understand?
Sure.
Okay. There's just no excuse. I'm going to test you 50 days from today. You know that you're going to get it. You understand? All right. Beth, done. Thank you, Ms. Good morning, Ms. Gibbs. Ma'am, you're charged with failure to identify oneself. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement where they're offering you 60 days in jail with credit for the 23 days that you've done. You need to understand that today you're making a lifetime decision. This case is going on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. You understand? You also give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So you can never come back and complain and try to change this. Is this what you want to do?
Yes, sir.
How do you plead to the offense, man? Guilty or not guilty? I'm gonna find you guilty. I'm gonna sentence you to it. I'll roll your cost so you won't owe anything. Good luck to you, man. Thank you. Thanks a lot.
May we please approach?
Did we work it out? We got it?
Yes, kind of, sort of. Okay. They failed to bring her over this morning, so she's not here.
We can do it tomorrow.
Yes, except that I'm going to be in San Marcos tomorrow.
Zoom.
And I think that's
Okay, pause. Let's break this down. The court's already organized transport, prepaid bus tickets, and even in Uber yet, there's hesitation about trusting her to follow through. What do you think? Should judges give second chances with this? Much freedom, or is this setting up for failure? Drop your thoughts in the comments.
the solution to either
You can
Zoom,
always Zoom.
but let me share with you, I think, kind of where we are, if you don't
Okay,
mind.
sure, sure.
I may need to approach. You had asked several questions when I was here before on the Gonzalez matter. Number one, the facility there is not going to be able to come and pick her up, okay? They
How
won't
do we
pick up
get her?
So what has happened, if I can approach you, what she has done is they've already confirmed and booked her bus trip that leaves at 8:20. And they paid for these ahead of time to get there, and they also paid for the Uber to get her from the bus station directly to the facility. And this has already been prepaid, okay? So it's gonna have to probably be modified now, but that's the only way.
And we're supposed to trust her that she's gonna actually do all this.
Because she will understand what the consequences are. I would say yes. I mean, if she doesn't, she knows what the consequences will be. I don't think that I would hope that she would not. And I don't think they'd go to this expense to get this stuff in order to make sure that she does comply. But if she doesn't, we'll know soon enough. Okay. But these may have to be modified. I think part of what was going on is she wanted to certainly show the court for good faith that she was coaching us with.
I get it. My only problem is she gets out and she tries to take a detour to go back home, to go say bye to dad, or she's got to go say bye to a friend, and then.
And I get that. I think that if you'll look at the date, it says that she's gonna leave on Wednesday morning, because we don't know what time she's gonna be getting out of jail. The idea was she's gonna be in court today and maybe get released sometime later this morning, Tuesday morning or something like that, and then be able to leave.
We can have precise release instructions so we know exactly what time she gets out.
Do we have that? I mean,
We can do that.
Is that something we can do?
Yeah,
I mean, if that's something we can do, then I guess we'll do that.
we do it all. And so that's how we do it when we release people to go to, the Ed Emmett place or any other place. We say, okay, she gets released at 2 p.m. on this day, and to this person. Here, can we? I know that we can do it. It's possible.
If.
This is the facility that she's going to is in Grand Prairie,
Right,
Texas.
it's in Grand Prairie, Texas, that's true.
I don't believe anybody from Grand Prairie will come and pick
No,
her up.
they've indicated they cannot, don't have the capability of doing that. They said we can't pick her up, and this is from Charles Cato, the CHGO, who is the admissions navigator for the American Addiction Center. He says we can't pick her up from jail and.
What's that document that lawyers have? Who has it? Anna, do you have one of those? Do you have that document, the releasing document that you use? Perhaps you could share one with us,
Absolutely. Give me just.
with Mr. Knowles.
I can,
I'm going to have them share it with you, and we can say time that we want her released. So we can say, guys, release her at this time, and we can also do a directive so that she's released at like 7 a.m, so that she can make it to this bus. So do you have an Uber that'll take her from here to the jail to this bus stop? How is she going to make it to the bus? Because this bus stop all the way to Harrisburg, that's far.
The idea, I think, Judge, was that her family was going to pick up and take her to the bus stop. And then the Uber here, the reservation for the Uber that's been paid for, takes her from there
Mr.
to
Knowles, I
the greenhouse eviction center here, is what this Uber was. So from the bus stop in in Dallas or Grand Prairie, wherever the nearest point is there, that she's going to get you there. That's what this represents.
It's just,
Judge, I understand, I respect the risk that we may be taking, but I think that her understanding the consequences, the repercussions that could occur.
have you spoken to anyone that's going to pick her up here? Do we know? To any family members that are
I've
really,
spoken to her daughter, which is who I haven't been in contact with, and that's who is intended to be picking her up. Yeah.
so we need to have like a deadline, I guess, check-in date, so to speak, where she must be checked in by, so the bus arrives in Dallas at 1:10. What time is that for the Uber you have there, Ms. Knowles?
The Uber, this pickup is gonna be the Greyhound bus
Right.
stop on Lamar.
Drop off at
It's a drop
2:20
off at
PM.
2:20 PM, it looks like.
Okay, so we need to verify by like 2:45.
Okay.
Wednesday, she's checked in. If she is not checked in by 2:45, Wednesday, a warrant issues. And I'm telling you now, I don't care what excuse that she has.
Oof, here comes the no more excuses moment. The judge is putting a hard deadline 2:45 p.m. check-in, no exceptions. But did you catch the subtle power shift? The defense gets to draft the order. Is this a smart collaboration or a risky loophole? Let me know if you spotted it.
I'm telling you, because there's just so many hiccups with this that could happen, and I'm trusting you that it's gonna happen. I'm not gonna take excuses, right? If she's not checked in by 2:45, warrant issues. Right? Because I have to put some kind of time on it.
She'll show up tomorrow here. She'll sign up on modified conditions.
Yeah.
Okay. Then the modified conditions are gonna have a time specific for her release.
Mhm.
Okay. Do we know what we're gonna make that time to be? If she's here
You
tomorrow.
tell me, because I'm gonna have you draft the order, because I'll have Anna give you a copy of the order,
Okay.
and then you just draft it in how you want at the time, and then the jail will release her at that time. And then hopefully the family will be there waiting for her to take her right to the bus stop, and she gets right on the bus to go. So you tell me what time. We could do it 7 a.m, because that bus trip is what, 8:20? So theoretically, maybe 7:30. We have her taken out of the jail, and the family picks up at 7:30, and then they take her to the bus stop.
With Greyhound, and then goes and picks that up there on Wednesday morning.
Yeah. Should we put a monitor on her ankle so we know where she is?
I don't think
'Cause-
she's gonna have time to do it. Because with probation, I don't have like
The prior to release, do you think we only think,
I don't think I can do that. I can try.
Just a suggestion, do we have her come get the monitor and then she can change the departure time?
no. You've already got everything ready to go. Just let that be, because that's already in place, ready to go. Let's not fix it if it's not broken, you know?
What I want to do is make sure, as much as the court does, that there's some mechanism that's going to control her coming and going, her GPS and all those kind of things. I know the patient when she gets there, but I want to make sure that we know exactly what's going on with her in terms of the travel from the jail to the facility. And I don't mind. I'm sure they wouldn't mind. Okay, let's modify the departure itinerary to allow her to have that attached. I would feel more
I'm willing to
comfortable with
forego it just so that she can meet the schedule. I'm not married to it.
that.
I want her to be checked in by, late Wednesday, and we can verify that she's in there. And then I guess what I'd like is maybe on a weekly basis, we just verify that she's still there, that she hasn't just taken off, because
No, Judge, I'm saying no. And again, all deference to I think the order modification should, because the facility will accept orders from the court, just as.
Okay, so,
no way-
right, okay, so let's say
So-
she cannot leave, she must complete the entire program. Is it, how long is it, do you know?
They have a 90, you asked about that, there's a 90-day commitment minimum, but can be extended. Of course, part of that extension is going to be based upon,
It needs to be as long as possible, right? As long as possible. I was hoping 180 days, right?
It
Because
can
that's
be
what,
extended.
Yeah.
It can be extended. There is a detailed aftercare program according to Mr. K.
no, right, but I went to inpatient for quite a while.
And I understand.
And then the aftercare, because that's
And
what.
then the aftercare
Right.
afterwards, but I'm saying the question that you had the other day was regarding do they offer an aftercare? And he responded, yes, we do offer an aftercare, and it's going to be based upon each individual circumstance that dictates what the aftercare is going to be. Let me go back just a little bit, Judge, because Murphy's Law has a way of following me and a lot of folks. The fact that she doesn't get there till 2:20 and it's 2:45 to check in, that bus is gonna have a flat. The Uber is gonna have an accident.
I don't know what to tell you there, Mr. Knowles, but this is why I'm telling you, I think we should do Santa Maria, because this way we know there's no issues. This is ripe with problems, and I'm telling you, if she says it's now Thursday, she's not checked in because, damn, I had a death in the family, or I had scoliosis, or I had to go to the hospital, or.
I'm not asking for that. I'm asking for 3:20 instead of 2:20. Give her an hour, okay? Just if the time that she is supposed to get there is
She gets to
2:20,
the facility at 2:20.
2:20 for the Uber, then I mean,
If she knows that she has time, she's gonna go do extra things, and that's what I'll. She knows. She's lucky that this is even happening. Okay?
Judge, and I want.
Really?
I know the whole reason why you're doing it, and I get that. So that's what we will do.
Yeah, all right. 2:45 check-in.
Yes.
All right.
Do you want me to necessarily zoom in tomorrow just to get her to modify or change over and sign off on the
I
conditions?
need you to, yeah, because I don't want to talk to her without you being present.
Okay.
You know, because I'm gonna explain to her everything, what we transpired here today, so she knows what the expectations are. If you want, leave me your cell phone, and then I can text you
Okay.
the exact moment that when she comes out, we can do it.
No,
Or whatever time is best for you, you let me know, and then we can set it up for that time.
that's fine, then I'll share, I'll
If you want to give it to Vic,
give Victoria.
yeah, and then whatever time you want, we could do it at that time.
Okay, sounds good. Thank you so much. Judge.
Thank you,
I
Mr.
appreciate it.
Mr. Perez, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 90 days.
This is the judge's ultimate warning shot next DWI. It's a felony with hard prison time. Notice the blunt, no-nonsense tone. The courtroom isn't just dishing out punishment, it's trying to scare defendants straight. Do you think this kind of direct approach actually works? Comment yes or no below.
Days in jail with credit for the 58 days that you have done. You need to understand that this charge now will reflect as a conviction on your record. It will be there for the rest of your life. Do you know what happens on your next DWI? Take a guess.
¿Me pueden tener mucho tiempo?
This can happen here for a long time.
Want to take a guess how much?
We never get tanto tiempo. Yeah.
From now on, if you ever pick up a DWI, you will be looking at a felony offense, and you will be facing a minimum of 2 years in prison, a maximum of 10 years in prison. And you don't have to be stupid, falling down, pig-ass drunk to pick up another DWI. With your record, an officer's going to pull you over. The mere smell will probably be enough for them to charge you with a felony offense. So if I were you, you have a sip of a beer, I wouldn't get into a car because it's a huge risk that you're taking. Not to mention, every single time you will get hit with an immigration detainment, just like now. So if there's family that depends on you, I would probably think about them. The agreement that you've worked out is 90 days in jail with credit for the 58 days. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You also give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Do you understand?
Yes,
Is this what you want to do?
yes, it.
Sí.
Yes,
How do you plead to the offense of driving while intoxicated? Second offense, guilty or not guilty? I'm going to find you guilty. I'm going to sentence you to the 90 days in jail, give you credit for the 58 days. I'm going to suspend your license for 1 year. Do not drive until you get a license.
no manifesta.
Good luck to you, Jim.
That's what I said.
Thank you, Judge. Appreciate it.
I was it.
All right. Good morning, Ms. Burnett. Ms. Burnett, you're charged with two cases, right? The assault, the disorderly conduct discharging. Is that right?
Your Honor, she's pleading to a criminal mischief and disorderly conduct.
This was the
Okay, so the assault is being dismissed. You're pleading guilty to the two other cases. You need to understand that both of those cases will go on your record. They're going to be there for the rest of your life. The reason that's important is because, number one, it now makes it a 90-day minimum on one and a 30-day minimum on the other if you ever pick up new charges. Not only that, if it continues with the same course of conduct, it's very possible they file a felony offense on you. So you need to be very careful moving forward. Do you understand?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, for possible immigration consequences, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, you can never come back and change these or undo this.
Yes, sir.
This is what you want to do. How do you plead to the offense of disorderly conduct? Guilty or not guilty?
Yes.
And on the criminal mischief, guilty or not guilty? I will find you guilty, sentence you to 180 days in jail. I'll give you credit for the 71 days that you've done on both. And good luck to you.
Thank you.
Thank you. Thank you, Mr. Mr. Oates, you were charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Judge, on August 29th, 2021, an officer was dispatched for a stalking call. The complainant stated that the defendant and she were previously in a dating relationship, but had been broken up for about a year at the time. The complainant stated she had to block the defendant's number because he was calling her excessively. On this date, the complaining witness noticed that the defendant's location was close to hers, which freaked her out because the defendant had moved to Oregon. She also stated that the defendant left flowers at her house and had told the defendant about 10 times to leave her alone via text message. The defendant refused to and said that he just wanted to talk to her. The defendant stayed outside the complaining witness's apartment all day and watched her. The defendant took a photo of the apartment and told the complaining witness to come outside. The officer detained the defendant. The defendant admitted to calling and texting the complaining witness numerous times. The defendant had sent over 80 text messages, which the complaining witness stated exclusively.
So I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond, not have any contact with this person and not to be possessing of weapons. Do you understand? Now, where have you been for the last 4 darn years?
So when I got out of jail, after my posted bail, I went back home to Oregon and I started my life again, and I just gave
It doesn't
up.
work like that.
Now
You go to jail.
and I understand that. See, when I was here, the lady told me, she was like, what are your intentions when you get out after bail? And I was like, I'm leaving. I'm not coming. I'm not going around her. I don't want to
Have an open case and you can't just take off and go to Abu Dhabi because you want to take the hell off, start a new life. No, it doesn't work like that. Appoint him a lawyer, please. Take a seat for me in the jury box.
I'm here on Mr. Osis. He's the gentleman that found out he had a warrant and walked in. I am here asking if you would reinstate
Come up.
his previous finding.
No, sorry. No, he's been gone for
So
3 years.
if I may, Judge, when he was originally arrested at magistration, the magistrate asked him what his plan was if she let him out. He said his plan was to go back home to Oregon, and she said, good, do that and stay out of trouble.
Are we supposed to take what he says at face value now?
And I just, Judge, he also has had no contact with the police for 4 years because he's had this warrant since 2021.
Did we look? Did you do an?
There's no FBI number, Your Honor. Let me check his state ID.
Do you need it?
I have it.
Okay.
Yeah, but because he had the warrant, if he had contact with the police in Oregon or Georgia or South Carolina,
Where
they
are you
would.
living now, Mr. Oates?
I live in South Carolina with my two best friends. One of my best friends is trying to get me a job with the construction.
Not now, while this case is open.
Well, I know, and that's how I found out about all of this, because I took my drug test and my background check, and they said that they couldn't hire me with an active case. And so as soon as I found that out, I called the court, and I couldn't get through, but I kept calling, and I finally got through. And then I told your assistant or one of your assistants that said, as soon as I get enough money to travel down there, I will be there. I'll pay my bond, and I will take care of this case. And so as soon as
How old are you?
27, sir.
So what are you doing?
Right now, I work for Dick's Sporting Goods, as in the process of trying to get the job as a construction worker, as a pipe fitter.
Okay, I'll reinstate, but I'll put a monitor on his ankle.
Okay.
You take off again. I'll never do this again. I'm not giving you another PR bond.
May I ask you a question, sir?
Sure.
So I do live in South Carolina. Am I allowed to go back? I can give you all the information. So I have to stay in
This
Houston.
case is from 2021. It's now time to take care of it.
Okay.
So I have
You
to
know,
stay.
really. Do you have an offer in this case now?
Not yet, Your Honor. We have spoken to the complainant. Being that it's so old, being he's coming in on his warrant, we can reach out and get a quick trial, quick reset, so we can talk to the complainant again, see where she's at.
And
Go from there.
Judge, we would ask for a 10-day trial setting.
Your Honor, that's just, he's
I mean,
coming in on.
I know.
It's his fault that he's gone. I'm not going
Yes.
to blame the state because of it.
That's unreasonable.
No. Right.
I
No.
apologize for that.
Do you see how many problems it creates?
Yes, sir.
Really?
I do.
You're supposed to live and you sign paperwork reflecting everything. So you need to read every single thing that you sign because there are consequences when you do whatever the hell you want to do.
Yes, sir.
All right. He gets an ankle monitor today. I'm going to reinstate his bond.
Okay.
So I'll give you as much time as you need,
Okay.
whatever you guys, but this case,
We can do a quick setting, Your Honor.
within 30 days, it's a clear trial. I'm not giving you more than 30 days. So
We'll talk about
you
it.
talk to her.
Yes, sir.
She'll explain everything to you, but
Yes, sir.
this case lives and dies within the next 30 days, meaning you must either accept a plea bargain or I'm setting your case for trial in 30 days.
Yes, sir.
So we'll give him an ankle monitor today, waive all the fees, no drugs, no alcohol, no weapons, no contact with the complaining witness, no going where she lives. And I don't know if he's had any kind of recent contact or not.
We will, again,
Right. Okay.
we'll check.
All right.
Okay, go have a seat and we'll.